Article 14 second video loike apanalok kokoloke swagatam janaisu. Chiranjit Lal versus Union of India ek case to important hoy karon yat Supreme Court decision disile je Article 14 guaranteeing equality before the law applies to all the person including corporation regardless of race, color or the nationalities. That means all the person includes what? All the persons include citizen, okay, plus aliens. Aliens means the foreigners living in the territory of India as well as the legal person. Legal person means what? Legal person means a company. Suppose the company is not a natural person because by the birth the company is not considered as the person. But suppose a company tour কিছুমান proceeding karone কিছুমান rights duties in that company tour uprat face kora hoise, and because of it that company will be considered as the legal person. Article 14 is applicable to all the person, let it be citizen, let it be aliens, let it be legal person. For all the person, Article 14 is applicable. Now, let's talk about one of the important provision under Article 14. The guarantee of the equal protection of law means the protection in equal laws. It forbids the class legislation, okay? Under Article 14, class legislation is forbidden. Now, what is the meaning of class legislation? Class legislation means those law যে particular class at a favor করে, okay? Which is basically arbitrary in nature. For example, I'm just giving you one example. For example, the government has exempted the landowner from paying any kind of taxes. Okay, that means government college landowner jiman bor ase teoloke kono dhoroner tax pay koribo nalage, so that landowner bilakhone jate teolokok vote diye. Okay, this is the class legislation. Such kind of the class legislation is completely prohibited under Article 14. Okay, there shall not be any kind of the class legislation. Now, Article 14 does not forbid classification which rests upon reasonable grounds of distinction. That means if the classification is just and reasonable, then such kind of the classification is allowed. For example, the government may provide the maternity relief, may provide the provision for the maternity relief to the pregnant women. Okay, such kind of the distinction is allowed, such kind of the classification is allowed, that only the pregnant women will be given the maternity relief. Nowadays, there is the new provision regarding the paternity relief as well. So, paternity relief may be granted up to 15 days, whereas for the maternity relief, in some cases, it may be granted up to 52 weeks as well. Okay, so such kind of the distinctions are allowed under the Article 14, which must be just and reasonable. Now, under Article 14, we have to remember two important terms, that is the intelligible differentia and rational nexus. What is the meaning of intelligible differentia? Intelligible differentia simply provides that the classification must be based on a clear, reasonable and understandable distinction that separates those who are grouped together from those left out. For example, law giving special benefits to economically weaker section is based on intelligible differentia. Now, what is the meaning of economically weaker section of the society? EWS was introduced by 103rd Amendment Act of 2019, and it simply amended Article 15, Clause 6 of the Constitution of India. So, কারোবাৰ যদি এনুৱেল আৰ্নিং 8 লাখতকৈ কম হয় তেতিয়াহ'লে তেওঁলোকে EWS অৰ্থাৎ ইকনমিক্যালি উইকাৰ সেকশনৰ সাৰ্টিফিকেটৰ কাৰণে এপ্লাই কৰিব পাৰে, আৰু জববোৰত 10% ৰিজাৰ্ভেশ্যন থাকিব EWSৰ কাৰণে। ওকে, আৰু EWS সদায় জেনেৰেল কেটেগৰীৰ পৰাহে হ'ব পাৰে, SC, ST, OBCৰ পৰা হ'ব নোৱাৰে, অৰ্থাৎ EWS is only applicable to the unreserved category. Now, in this scenario, we have to remember ইয়াত এটা differentiate কৰা হৈছে, okay, there is the classification. যাৰ 8 lakhsতকৈ কম ইনকাম আছে আৰু যাৰ 8 lakhতকৈ বেছি ইনকাম আছে. So such kind of the classification is allowed, okay, because it is based upon a reasonable ground. That's why such kind of the classification is allowed. Now, second important term is rational nexus. Rational nexus simply provides that the differential must have a reasonable relation to the objective the law seeks to achieve. That means আমাৰ এই যিটো ক্লাছিফিকেশ্যন প্ৰভাইড কৰা হৈছে এই ক্লাছিফিকেশ্যনটোৰ মেইন অবজেক্টিভ কি হয় এণ্ড দ্যাট অবজেক্টিভ মাষ্ট বি আ ৰেচনেল অবজেক্টিভ অ'কে ৰেচনেল অবজেক্টিভ মিনছ টু আট ফৰ এক্সাম্পল when EWS was allowed, EWS কিয় certificate কিয় দিয়া হৈছে so that যিবিলাকখন আমাৰ unreserved category যিবিলাকখন candidate থাকে তেওঁলোককো যাতে আমি uplift কৰিব পাৰো okay তেওঁলোককো যাতে uplift কৰিব পাৰো যিবিলাকখন ইকনমিক্যালি বেকৱাৰ্ড হয় জেনাৰেল কেটেগৰীৰ পৰা আহিছে ইকনমিক্যালি বেকৱাৰ্ড হয় তেওঁলোককো যাতে আমি uplift কৰিব পাৰো তাৰ কাৰণে EWS ৰ কনসেপ্টটো অনা হৈছে so this is the object upliftment of the economically weaker section of the society but suppose a law has been passed to provide a classification and under this classification suppose the people who are earning 20 lakh per year they are given some kind of the tax exemption okay they are earning 20 lakh plus income per year still tax exemptions are given to them okay so ইয়াত কোনো ধৰণৰ অবজেক্টিভ নাই মানে তেওঁলোকক জাস্ট এপিস কৰাৰ কাৰণেহে such kind of law বনোৱা হৈছে so this will not come under the rational nexus okay so basically rational nexus means the objective must be our rational to the welfare of the society welfare of the society karone kisuman classification allowed kora hoy and one of the best example is EWS এতিয়া ইছু এটা খুবই ইম্পৰ্টেণ্ট কেছ ল আণ্ডাৰ আৰ্টিকল 14 ডেট ইজ এপি ৰেপা ভাৰ্চেছ ষ্টেট অফ তামিলনাডু আৰু ইয়াৰ জাজমেণ্টটো দিছিলে 1974 ডেট মিনছ AIR 1974 In this case law, the Supreme Court said that equality is the dynamic concept with many aspects and dimension and it cannot be cribbed, cabined and confined. So, কেতিয়াবা এক্সামত কুৱেশ্যন আহে যে আৰ্টিকল 14ৰ আণ্ডাৰত ইকুৱেলিটি ইজ দ্য ডাইনামিক কনচেপ্ট এণ্ড ইট কেনট বি ক্ৰিপ্ট কেবিন এণ্ড কনফাইন বুলি কোনটো কেছ লত কোৱা হৈছিলে আৰু সেই কেছ লটো হ'ব এপি ৰেপা ভাৰ্চেছ ষ্টেট অফ তামিলনাডু নাও Again, one thing we should have to know under this case law that in this case law, the Supreme Court held that arbitrariness and equality are sworn enemies. Okay, and thus any arbitrary action is inconsistent with Article 14. That means Article 14 only class legislation okay prohibit coroner, but Article 14 also prohibit the arbitrary executive action as well. This was the judgment in this case law, that is the Pirappa versus State of Tamil Nadu. Then another important case law, very important case law, that is Maneka Gandhi versus Union of India, and the judgment was given in the year of 1978, and that's why AIR will be 1978. In this case, the Supreme Court held that Article 14 strikes that arbitrariness in state action and ensures fairness and reasonableness. So reasonableness and the fairness or যেটো concept আছিলে সেই conceptটো Maneka Gandhi versus Union of India discuss কৰা হৈছিলে Maneka Gandhi versus Union of India case law to Article 21 of thoroughly discussion কৰা হ'ব Article 14 or under only we have to remember one thing that in this case law it was held that Article 14 strikes that arbitrariness in state actions state নিজৰ মতেদি সকলো কাম arbitrarily কৰিব নোৱাৰে Such kind of the action must be reasonable and justiciable and if the state is acting in arbitrarily then such kind of the actions can be declared null and void and state can be held responsible as well. This is all about Article 14. আমি এই ভিডিওটোত Article 14 or definition কি প্ৰভাইড কৰা আছে আৰু আৰ্টিকল 14ৰ ইম্পৰ্টেণ্ট প্ৰিন্সিপল that is the intelligible differentia, rational nexus and arbitrariness and কৰিছে তিনিটা প্ৰিন্সিপল আমি ডিসকাশন কৰাৰ উপৰিও ইয়াত ইম্পৰ্টেণ্ট কেছ ল এপিৰাপ্পা আৰু মেনকা গান্ধীৰ কেছ লটো আমি ইয়াত ডিসকাশন কৰিছো আশা কৰিছো আপোনালোকে ভিডিঅটো ভাল পাব আৰু যদি আপোনালোকে ভাল পাইছে ভিডিঅটো লাইক কমেন্ট আৰু শেয়াৰ কৰিব ধন্যবাদ